5 seconds to go. Start. The main issue that arises in this case is whether the High Court was justified in passing a drastic order in the exercise of writ jurisdiction under Article 226 of the Constitution of India pertaining the first and second respondents writ petitioners to construct a compound wall under police protection. The order passed by a division bench of the High Court on 16th March 2022 is in terms of the minutes of order tendered to the court by the advocates representing the parties duly signed by them. The practice of passing orders based on minutes of order submitted by the advocates representing the parties prevails perhaps only in the High Court of Judicature at Bombay, for short, the Bombay High Court. The present appellants applied for a review of the order dated 16th March 2022, which has been rejected by the impugned order dated 20th July 2023. Even the order dated 16th March 2022 is under challenge in this appeal. A few factual aspects will have to be noted. Arbitration petitions were filed under Section 9 of the Arbitration and Conciliation Act 1996, for short Arbitration Act, before a single judge of the Bombay High Court. One petition was filed by the first respondent against one Urvaksh Nawal and others. Taj Nawal Nariman and another filed the other petition. Consent terms were filed in the arbitration petition preferred by the first respondent. It appears that during the pendency of the proceeding of the arbitration petition, Urvaksh Nawal was arrested by police based on a first information report. In terms of the consent terms dated 28th April 2018, the learned single judge passed an order dated 30th April 2018. Further, order dated 10th May 2018, passed by the learned single judge, records that the process of handing over possession of the suit property by the respondents to the first respondent has commenced. The dispute in the arbitration petitions related to the lands of Parsi Dairy Farm. The seventh respondent in arbitration petition number 451 of 2018 filed an interim application in the disposed of arbitration petitions more than 2 years after filing consent terms. It records that the High Court had directed the police to give police protection to the parties for completing the process of handing over possession. A compound wall was to be constructed in terms of the consent terms. The occasion for filing the applications arose as, according to the seventh respondent in the arbitration petition, local persons obstructed the work of the construction of the compound wall. The learned single judge of the Bombay High Court disposed of the interim application by his order dated 12th February 2021. The relevant portion of the said order reads thus: in the application, it is stated that in order to safeguard the suit property, the parties tried to build a wall on the suit property and which is in their possession. On commencement of the work of building the wall, the parties have faced several difficulties and which are enumerated in paragraphs 5a to 5d of the application. It is stated that local persons have time and again obstructed building of the wall, and despite several requests made to the Talasari police station, nothing has been done. It is stated that a wall is being built on the suit property in order to secure the same. Stop.